Good afternoon, everybody. This is the Law Revision Commission on Juvenile Justice. The time is 12:15. The date is Tuesday, January the 10th. I want to acknowledge the presence of the members of the commission, beginning with His Honor Judge Barcinas, representing the AG's office. We have Mr. Tydinko and Ms. Sanchez, the compiler of laws, Ms. Cepeda, the Director of Youth Affairs, Mr. Mendiola, the Chief of Police, Mr. Berdalio, the Director of Mental Health and Substance Abuse, Mr. Affligui, Mr. Gillen, the Director of Public Health and Social Services, and Ms. Taitino, the Superintendent of the Guam Department of Education. We also have additional staff who have really been the workhorses behind this committee, and I'd like to acknowledge them. From my staff is Sarah Nedidog, Dr. Rapadas from Mental Health, Phil and Carol from the AG's office were at all the meetings. I want to acknowledge their presence. Mr. Anderson and Ms. Taitino Ms. Tenorio from Mental Health and Department of Public Health and Social Services. By the way, congratulations on your being awarded the Commissioner's Award for your work with children. It's very well deserved. And I just wish the statistics weren't as high as they were that was reported yesterday, but it obviously shows that you're out there, and that's what is recognized by the Commissioner, and I'm sure all of us in the Commission recognize and applaud and commend all of your hard work, and that's very hard-working staff, I know. We didn't mention it the last time, but they were even working on Christmas Day to rescue those abandoned children, and I think publicly that effort and that kind of diligence should be commended and recognized. I want to thank everybody for coming today. We have several things to discuss, and we also need to... Did everybody get a copy? We'll get to it in 8, but I didn't know if the draft, and I'm going to very big D-R-A-F-T on the proposed legislation. There's many things that need to be done about that. That's not something, that's conceptual, and it's just whether or not we want to do something like that, whether or not we want to statutarize it and permanentize the commission, and but we'll get to that in 8. I think we still have to go through the recommendations that have been prepared to us by the working staff, the working group, and we're at the Superior Court. And, Your Honor, will you be leading the discussion, or are you going to have... Oh, Sarah will. Okay.
Thank you, Vice Speaker. Again, the process for developing these work group recommendations were that the various entities developed 5 or identified 5 problem areas and came up with 5 recommendations or solutions. They made the presentation to the bigger group, and the bigger group then, after review of the compiler of laws recommendations, made a determination as to what action, if any, should be taken. So as you will note, on 6 and 7, they're divided between Superior Court probation, and 7 is Superior Court client services. And the person that made the presentation for Superior Court probation, I believe, was Rudy Gaza, and Virginia Yasuhiro made the presentation on 7.0, and then 8.0, which we hope to cover today, were general recommendations that were made afterwards that may not have specifically it didn't fall under any specific agency, but were general observations and recommendations.
I'm sorry, Mr. Garza, did you want to do the presentation for the court, or?
Well, I guess we gave one earlier, so I thought we were just going to go.
Oh, okay. Then we'll
Just-
go ahead.
Okay. At this point, Vice Chair or Vice Speaker, I think we should just go ahead and just go ahead and do the vote on each one, unless there's further discussion. Okay. You want to explain each one? Okay. Jump in, Rudy, please, if you need to elaborate on any of the areas. 6.1 was the detention of juveniles, and the recommendation made by probation was to disseminate a uniform policy to the court and all agencies so that all are aware of the circumstances requiring placement. And this, there was a lot of discussion by the work group on this, and rather than make any amendments on the law, the recommendation was to develop the memorandum of understanding to ensure that there's greater interagency coordination and communication. So having a uniform policy was not one that the group felt was appropriate at this time, but more so MOA that kind of laid out what the different policies and procedures would be to guide the relationship and the work assignments within the different entities.
Does everybody understand that issue? I think that depending on who is the current judge of the juvenile court, the director of youth affairs usually has to do a little orientation on how often and who all gets placed up at DYA. And I think, going to the point that Judge Barcinas recommended last time, there really needs to be not only an MOA, but it has to be up on a website so that when they rotate, and if the DYA people, either at the AG's office or at probation, rotate out, that everybody understands that this is the policy. It may not be written in law and stone, but this is the policy that has been implemented over the last several years, and it's the recommended policy for the judges to utilize. I mean, I wouldn't want to preclude the judges from exercising their own discretion, but it at least allows for them to understand the parameters by which the decisions are made for detention, release, and diversion. So who would the MOAs be between DYA and the court, probation and DYA?
I'm sorry, Judge. I would just thinking off the top of my head, definitely the DYA, the court, the judges, the probation office. I don't. Yeah, and maybe even CPS. Yeah, and DOE.
And
Because we do come into a lot of problems when we have situations where the kid is with us, and or I'm sure with other agencies, and we just don't know where the kid should end up at. And also coming out of court, the judges make rulings and they say the kid should go here, probation take the kid here, and then we get there and then we have some misunderstanding with that agency, and so it's just really, we just need to identify who goes where, who makes that decision, and that the receiving party has that same understanding as to why this child is being brought to them.
anybody else wish to speak on this? Any concerns? I'm sure you do.
At the youth correction facility, it's oftentimes we feel we're the last resort for many cases. CPS obviously has the challenge of placement, foster care, and what have you. We do oftentimes have to take the kids in for our status offenders into cottage homes because circumstances prevail, and that it's the best choice at the time. But you're right, a lot of times, it's late hour, it's the late hour, it's after hours, and it's the only place to put them, and notwithstanding the limits of our capacity and the current condition of our facilities, which is a work in progress by itself, it would be important to have those 24-hour numbers, such as how GPD has the AG's office at a moment's notice being able to reach them, so that we can come to some kind of consensus on the issue. So I think that communication, that gap there probably is the largest point of contention, that we'd be able to get the assessments quickly, if need be. We know that the child may or may not be further traumatized by being put into our hallways, so to speak, and then be able to have some sensitivity on the part of those who have custody of the child at the time, with or without the remand order or other issues, to be able to say, okay, we'll go ahead and float the overtime so that we can work this out. We'll be able to coordinate this and have somebody on call. So with regards to that matter of placement, we really appreciate having that open, and I think the MOA is a start, and I think I think we can all agree upon that.
And I'd also like to acknowledge the presence of a representative from Sanctuary, and though they've already destroyed all the voodoo dolls that they used to stab when I was the juvenile court judge, maybe Sanctuary might want to chime in on this, George. Since you came, I want you to have something to say.
Well, I know that with our organization, we like to be as helpful as possible with a lot of these kids that are, faced with many challenges. If they are a first-time offender, and that, we like to see them come into our agency. Well, first of all, be recommended, not ordered, and then we'll do an assessment, as opposed to having to detain them at the, cottage home or, place over at the youth correctional facility, if they are deemed appropriate for our services. I know that I can go back many years when Judge Cruz was the family court judge. He would look to us first to figure out if it would be okay to place this child in a more home environment, in a more home environment, or that wouldn't be less detrimental for the child. We want to continue to see this happen, where, like Rudy was saying, if there's just no where that this child can be placed, and we feel that we don't need to put them at cottage home, maybe look into our agency and see if that would be an appropriate placement. I know Judge Bursina has done many of those already, but we like to see that continue to happen. We like to keep as less involvement with the system, so that the parents can continue to be a big part in the child's life, and be a part of the decision making and all of that. So I want to see that happen again, as the way I saw it 2 decades ago, when Judge Cruz was still on the bench.
Can I just add, you brought up something really important, because when these kids come into the system, oftentimes they're either picked up and detained, or they've been detained, so we have to charge almost immediately because of time frames. And maybe an MOA between DUI and Sanctuary, where if DUI deems this minor should be placed at Sanctuary, maybe that it could be done either before the court proceeding, they can contact. So an MOA that can allow the two agencies to handle it. And then, of course, when they get to court, they're going to say what occurred is that the minor was transferred into sanctuaries. Although the minor is still before the court and considered detained, he or she's now being detained at Sanctuary, because that's a proper environment for the minor based on the offense that was committed. so that, that could be worked out. Because what's going to happen is, of course, the judge is going to say remand to DYA, because we don't know how long sanctuary is going to take to assess the situation and deem this minor eligible for sanctuary or not. And so if it's an automatic something that can happen between the two agencies through an MOA, then it's better, because then we don't have to, the court won't have to order it. It'll be done and right away flagged into the court proceedings. And then probably another thing is perhaps an expansion of DYA, and I know I've brought this up to all the directors, an emergency placement. Another facility that is considered an emergency placement, because I really think it's needed. And the reason I say that is because sanctuary is limited to mostly juvenile special proceedings cases and not JDs. So when a minor has a prior JD and then now has a new JP case, the minor will not be eligible for sanctuary, and this minor is either going to be in cottage or at the correctional facility. So if we have this emergency placement, a temporary transitional emergency placement that where it's away from the two others, or even within the area, but just its own facility, it may assist with some of the cases where the transition of these minors aren't going to be long time detained. It's really hard because he and I, we have no choices. We only have DYA. Sanctuary is not a government facility. It's a nonprofit, so they have their criterias, and we understand that. But if they can do an MOA where we don't have to be involved, and they make that decision and they tell the court we're transferring this minor to sanctuary under their supervision, we're fine with that. Yeah.
And Chief, this kind of highlights the reason we need this commission and why we need the websites, because those powers already exist, and they existed at a long time ago, and those kinds of understandings existed a long time ago, and there's nothing stopping DYA from contacting sanctuary. Those are the interventions that occur long before a child gets to court. From the court's perspective, by the time you reach us, we're the end of the line. We're the last stopgap and hope for the child, where we start ordering services. And so I think what's happened over the 2 decades is that we've had changes throughout the system in leadership, philosophies, and personnel, and those changes have an impact as they go down the line, and that's why we need the Commission's website and the philosophies laid out and the memorandums laid out, so everybody knows historically how we do things and how we do things going forward. So it's just a matter of getting that consistency in a more formal setting in our commission.
And probably might also help for DYA to be advised and be told that once we sign the order giving it to them, they really are in charge. And they should be able to move them to sanctuary. I mean, I think that's been pointed out with the Lindsay Lohan thing of you're 30 days in, but you only spend 23 hours or 3 hours. It's once it's given to the executive branch, it's out of the court's hands, but the order's already been made. So I think that's why I wanted sanctuary to speak up, because I wanted this MOA to also include them, because if we're dealing with some of the truants or some of the
And also
the,
mental health kids.
mental health
The
kids.
important, DYA, an MOU between mental health as well, where they need to transfer into the care of mental health, should there arise a mental health issue. Because we have a lot of those cases, and it's hard because sometimes we need court orders to get by these obstacles when really we don't need a court order.
Sure.
It should be something that is automatic, given the kid's situation and assessment. We have so many professionals, Dr. Pottis at DYA, doing all these assessments and everything. CPS sometimes has a challenge. We gotta call sanctuary and beg them, or alley shelter for placement when we have a kid who comes in and we don't want them at DYA. We know we don't want them there. We want them elsewhere, but we gotta make these last minute calls, and sometimes it's after 5. So it's so hard to make that transition happen as quickly as we want it to happen. We gotta wait for the next day. So they've been really good at and really receptive. Also, alley shelter, but see those things. It should just be all in line where if a transfer needs to be made, there's an MOU that will allow that, or an understanding that would allow that automatic transfer.
Yeah, you talked about mental health, because I think that there will be times where the kid is compromised mentally, and that I believe mental health has a 16-bed facility, CIU, and I don't know if it's normally full anyway, usually, and actually that'd be really appropriate because sometimes, because we're not a detox and we're also not, if they're suicidal, we'll ask them to take them anyway. So we'd like if it's almost like an easier way to get in versus having to go through the intake and then see a psychiatrist. More like, trust us, we think that this person really needs to be sitting in a clinical facility for at least 48 hours before they go into court, so they're kind of stable when they come into court. So I think we could work on that.
I wanted to also say that, Lydia being around here, Lydia continues to utilize our services, and it happens 24/7, and we're very receptive to a lot of those. And Lydia is very much aware that, they look to us first, as opposed to having to incarcerate those kids, and that is something that continues to happen. I actually want to address the GPD, though. Pardon me if I'm going out of context here, but I think one of the things that used to happen many, many years ago, and it doesn't really happen now, is that whenever families call for help, and GPD are, in many cases, the first responders, I think we need to go back to the table and to start educating the police officers again, to look into the matter, assess the situation, and if you feel that having to refrain from incarcerating the kids, to give us a call first so that we can get involved in the intervention and determine from there if we should be able, if we're able to provide those kind of services, because we see a lot of those kids that are considered beyond control, yet the police officers will lock them up right away. And then really, there's no need for that.
I would like to add that Sanctuary, in our early meetings last year, we were able to, excuse me, we were able to hash out the issues with the JD, answering to the JD, and I believe we had overcome quite a few obstacles, if Mr. Salas had recalled, and so that we ironed out quite well. As far as the MOA, MOU, obviously there are conditions within their contract and has been that might prevent us or preclude them from taking in some kids, but I would definitely love to see how we can cross that bridge as well going forward, even with the new contract and having been processed. I would like to add, though, both the Chief and Mr. Chief Berdalio and Mr. Afflegui and myself just came from the Safe Think Tank meeting, a little bit off topic, but still in line with what George had said, in that there was a lot of thought process. This is the Safe Think Tank that was commissioned by Senator Adolfo Palacios, who's off island, but Senator Yamashita administered this, and a lot of thought went into the cultural differences, diversity, and of course the sensitivities we need to have when dealing with the different cultures on our island. But as it pertains to the system, being able to provide those interventions, and again the players involved being the first responders, being able to be open to how we can keep the kids from entering the system altogether, and maybe even go to the root source, being the families. I just wanted to add that. Thank you.
I just want to add in, because it's a challenge with the police department. We have minors, and the issue about detention is important. And what happens if it's not something of a criminal nature and stuff and all that, and Sanctuary is a resource. And I'm just saying, too, also that I'm not too much familiar with the school up there in Santa Rita where they have the PACE program. And we've used schools as typhoon shelters, when there's real emergencies. And there might be some legality there, because it's been brought up when we're talking about the schools having someone living in those schools and as a night watchman, but if there's capabilities of finding space, I know he said mental health, but if there's capable of having a facility, an additional facility, like I said, for emergency purposes and having people there, I'm just saying that's the kind of thing that I think the commission should explore as a whole. So when we're looking at resources of where to put them, because we have jail cells at the police station, but we certainly don't want the minors to be in the jail cells there.
Thank you. So on the recommendation by the work group, is everybody in agreement with this one? All right, we'll take that as a 9. And on the next one, concerns with DOE. I don't know what the BMP means, so I'll let you explain it.
Oh, can I have the courts?
We have kids in the school who have special needs, and they have a behavioral management plan that they're supposed to follow, like when these kids do act up in the schools. What we've seen happen is that the schools are very quick to call us when these kids start to act up. And we in talking to and basically how it happens is that we get faxes or we get calls and says, so-and-so is acting up, you need to come take so-and-so out of here. So our concern is, and like Judge Borsina said, I mean, we're the last resort. I mean, if you call probation, you know what's going to happen to that kid. That kid's going to go up to Manila. I mean, that's the reality of it. If you call us, we're going to come and we're going to take the kid up to Adonis's place. So what we're asking is that we're asking this, yeah. And so basically what it is that a lot of times we come to find that they're not following the plan. And, the kid acts up, and then we come and calm the kid down, and then we take the kid, and then talking to the kid as we go. It's like I acted up and they threw me out of class. We're thinking, well, did anyone come talk to you? Did they explain to you why this happened? It's nothing. It's quick to call probation, and then what happens is that they call us, and we generate a violation, and we give it to Judge Barcinas. And then Judge Barcinas agrees that, yes, they're, probation, they're going to be suspended. This kid will be suspended for 10 days, and, 10 days, you can't be 10 days out of school without coming to court and seeing a judge to see what the problem is. And so we generate the violation report based on what DOE gives us, and then we give it to the judge, and the judge signs off on it, and then we go out and do our job. But what we're asking is that maybe there's a better way to handle that, and if there could be contacts in the schools for us to talk directly to the person handling that case, so we don't have to take that route. So we don't have to put these kids up at DYA. And I know Adonis and Dr. Apolos have been very vocal about us putting kids at DYA, especially kids who have special needs. But really, once we get that call and once we get that violation or once we get that suspension, there's nothing really, the probation officer's hands are really tied. And then we go to the judge and, and it goes to him, and his hands are basically tied like ours. And so we have no choice. We take the kid, we bring him to DYA, and then he comes to court and he goes before the judge. But, to lock that child up for something that maybe didn't have to be locked up for, if an MOU can satisfy that between us and DOE, that'd be great.
If I may, in fairness to the school, most of the times when we find out that a child's behavioral management plan hasn't been followed, it's because that particular school is not aware of the behavioral management plan, or the administrators in that school. And by the time they get to the courthouse to answer about the behavioral management plan, they're now aware. And so I think a lot of the problem is, again, that communication that needs to follow with the child. A lot of our sensitivity now to these mental health issues and things come from our training with Ifamagonta and Department of Mental Health. and I'm not sure the extent and the level of which they engage and train with the school administrators currently. But if we have a commission with a website that can address these issues at the more strategic level, and then make sure it gets the word down. But we're not alone. We can't just act alone, because it's true, Dr. Rapadas does hold us responsible in his reports back to us, like, Judge, this child has a BMP, and why did you guys send him in here? Then we have to ask that next question is, why did we have him here? Okay.
So maybe if DOE can just sort of just maybe expound on that issue. And DOE humbly accepts that reflection on the fact that you may have students who have BMPs or are receiving special education services, and an administrator is not aware of the fact that they have a BMP. I know the concern, and we also humbly receive the concern from probation as well. And I think this is an issue of training for administrators, of course, and school personnel to ensure that, because as a former administrator, of course, if a student has a BMP and is receiving special education services, and the student did something, had some kind of behavioral infraction, and the school was not following the BMP, then the student is not held, should not be held responsible for their actions, meaning suspensions or whatever kind of consequence the administration may want to impose upon that student if the school was at fault for not following the BMP. So when a school calls and is trying to get the probation officer, because they're aware the student's on probation, to get them to come down and take the student out or do something, it may be helpful, again, I don't know if it has to be as technical as an MOA between DOE and the judiciary, but it's just maybe a training piece even for probation officers to, as a child advocate, just make sure, if you know that child has a BMP, to sit and talk with the administrator to ask those hard questions, because, again, they could be ignorant or not aware of the fact the child has the BMP, or maybe they are aware and they're just being irresponsible in their responsibilities as administrators to try and enforce a consequence when they know in fact that the school did not follow the BMP. But I think that's the issue, is a training piece on DOE's side, and some kind of interface between probation officers and administrators to ensure that if that is the case, that the schools are taking some ownership about not sending students out for not following the BMP.
And I was going to say, I think a policy, though, is probably perhaps important, because we want to, first of all, make sure that it's distinguished, a kid with a BMP and a kid that doesn't have a disability, because, when the BMP is entered into, we know that this kid has some disgruntled and disobedient behaviors. That's why it's entered into. And it shouldn't, it can only be followed for so long before intervention is needed through the court system. And so maybe a protocol or just an SOP or an MOA between these two to understand at what point, or just in your area, so that you can train your staff at the schools, that these are the protocols to follow. And at this point, when it elevates to this level, then intervention with probation should be called, because we don't want them to keep violating the BMP and you're just taking in-house action because of the BMP, because at some point, it's not effective. We need to bring them right back into court and, ensure that we get this kid evaluated further to see what's going on. Because I think that would be the obstacle, is if there isn't any protocol or there isn't any agreement between the two agencies as to where and when they're going to step in, you may never want to call them again after this discussion today, right? And so we don't want that. I don't want that to happen. I don't want you to not call them when you should call them. So I think like a protocol should be done.
No, as when I was at Agata Johnson as the principal, I was interested and eager in making sure that the assistant principal who was handling discipline was contacting probation officers when a student, when we were aware of the fact that the child was on probation. Not because we wanted to kick the can and move the issue to someone else, but it was really to make sure that the probation officer was aware of what happened with that student, so that, because again, these are violations of probation, then some other actions are supposed to happen. But again, if administrators are just trying to kick the can or move the student and have someone else have to deal with the issue, then that's a completely different issue and has to be addressed. But there is some value and utility to again, administrators communicating with probation officers when students are in violation of their probation, so that, again, we're all working together to support that student, and that everyone is aware of what's happening and what can be done to address the student's behavior.
And I think what had been brought up earlier on is the need of counselors and social workers to appear in court or at least submit written reports. Because I think it's important for us to know that, this kid had these infractions in school in violation of the BMP, and these are the actions that we've taken. Because it's important for us to know and just remind this kid. I mean, we
Sure.
don't want to punish them to detain them. We want to be able to explain to them and see what other services we can give or offer. So I think it's like, that's why steps are important, and at the same time, reporting to the court is important versus probation. Because probation is going to pick up. They're gonna detain.
Sure.
So if you were to have your social workers or counselors appear in court, then what would happen is at least they would be reporting to the court that, this minor's doing well, but this is the minimal
Right.
behavioral issues that have popped up in classes or, during breaks or whatever.
So I know internally we're working on that issue about the guidance from legal counsel to not appear in court unless subpoenaed to do so. Because Doris Bukikosa is here, and I'm going to be leaving for 6 months for some training, and she's going to take over my responsibilities for that time frame. But she's also the lead social worker, handling all of the social workers for DOE. And we've had these discussions based on what was brought up at the JJC. And again, that's just an internal thing that we just need to work out to make sure that, if our legal counsel is giving that kind of guidance, that we should not report to court hearings unless subpoenaed, that we can maybe get to understand that better. What are the circumstances as to why that may be the guidance being provided by legal counsel. But as per my conversations with Doris, and of course she can speak for herself, there's no issues with social workers wanting to go. As a matter of fact, she understands the benefit of that. Again, the more information a judge has in terms of what's going on with the child and what interventions may have been implemented but not effective, all that can only be helpful in terms of trying to figure out what supports need to go forward, right, for that child.
Chris, may I just comment? I like your word. The internal is the important part. So, if I'm not correct, if I'm wrong, whatever the whatever, blah. Okay, correct me if I'm wrong. Wrong me if I'm correct. Yeah. If a kid has a BMP, they're under special ed. Is that correct?
Mm-hmm.
Now, would every child who's under special ed have what we call a special ed counselor? Or
CRT.
That's a teacher, isn't
Consulting
it?
resource teacher.
Teacher. But isn't there also like someone like, what's his, Jason, or
Jason.
Jacob?
Oh.
Okay. Okay, so to me, obviously, if it's already done, that's the first phone call you make. I think the second phone call would be a social worker, the 22 social workers that are in DOE is a
No,
second.
let me just clarify, because
Yeah, please.
we're talking two different things here.
Oh,
But,
okay.
what I meant by CRT is that every school has a CRT, consulting resource teacher,
Okay.
or an IEPC, which is an individualized education program coordinator. And
Every school has one.
This person is responsible for overseeing
all the special-
meetings that take place regarding students who are receiving special education
But they're
services.
not an interventionist, so to
No,
speak.
not necessarily. They're more just making sure
See,
administrative.
and I think if I were a teacher, I'd want an interventionist, and I don't care who it is. So, but I think a DOE would have to focus on internal interventionists first, which would make it more in the family, so to speak.
Yeah.
So, if it were
But
someone like
immediate-
Jacob or someone a social worker,
But as Doris said, if the student is, their disability is emotional disability.
they would
right?
have one.
That's a unique
Right.
and specific kind of disability.
Right,
But in
and-
terms of students who are receiving special education services who are getting in trouble, who aren't necessarily ED students, the issue of the interface or the communication between probation officer and the school, the CRT is a good person to
Okay.
also consult with, because that person should know all the particulars of every student who's receiving special education services.
and that keeps it
if
internal.
they have a BMP or not.
Right. So that and a the DOE social worker assigned to the school should be contacted first, then kind of get together and talk about it. And then maybe if it rises to the level of, some serious offense, then either the cops or probation are called.
Right.
And if they're our kid, too. If they're our kid, you can call us, too. Right. So, just thinking.
Yeah.
But thinking internally first would be probably a good thing.
Are you saying, Chris, that the department is going to take the stance that they need a subpoena every time to appear in court?
No, no, I'm just, I know it was mentioned. And
Because I
even-
just need to know how much paper I need to order.
No, I mean, I'm,
work on it.
I'm acknowledging the fact that it was brought up. Even our staff have indicated that that's the guidance that they were given, but internally, we need to, you know, of course, the superintendent is here to force the issue.
I'm just suggesting that perhaps in the ordinary work of course, social work, that the social workers involved with the child in the school level should just show up as a matter of course, because it's important to know what's going on in terms of legal consequences, not to mention all of the information that gets exchanged in that courtroom over the course of a 20-minute hearing where every agency involved with that child is pretty much just downloading.
Yeah.
And so that's an excellent point to be, to get the communication and the coordination and to raise your hand and say, someone else needs to be held accountable here because they're not responding to the school.
Right.
And so I'm just suggesting that the social workers, at a minimum, who may be engaged with that family, should be exempt from the subpoena regulation that might be coming out.
And I think along the lines of what you're thinking of, Dr. Rapadas, is the case management again of this child, because we're not looking at something, we're not looking at a punitive response. We're looking at something that, intervention that's going to help to diffuse the situation that's happening at that point and move on from there. And so it seems to me that if we do contact probation, because we have the same, you know, we experience the same thing. If we know of a kid that's under probation, we like probation to be called upon because they have that authority and that deterrence kind of influence over this child. So we're not asking you to, you know, to just lock them up immediately, sign off on a violation. It's asking for your presence so that you can reinforce what you need to do in your role and in your capacity. And at the same time, I think it also doesn't preclude the role of a probation officer to go beyond the informal type of counseling. You know, like, these are the consequences. You're just going to have to play the role of a parent with these juveniles and once again reinforce what you need to do. But we're not asking for the punitive, formal file declaration, take it to the judge, and you know, and if it means the social worker within the school or the school personnel to call that RAP session, you know, that's when everybody comes into the picture and we can handle it that way. That way we save time at the courts and we don't have to bring it to the levels of the courts. But that's all we're asking for.
And I think with the reports, it'll ease the need to, you know, what happens is when it goes to court and there's an infraction, you know, of course, we have to take our actions because of violations of probation or court orders. But if there's that intervention side of it and they report to us that these are the steps we've taken to address this, it would ease us down, you know, rather than punishing, we would look at that, or rather than, you know, placing some type of sanction on this kid's behavioral problem. Yeah, it's really important because then we can say these have been taken and we think it's going to help, and, you know, we're just going to go ahead and let the school continue on with its intervention, and then we can move forward easily versus us knowing and not knowing what's happening. And, you know, we're going to be concerned. We're going to ask for something to occur on our side. So if we know something's happening on their end through reports, it would ease down what we would want to do on our end.
With this MOA that it says, the recommendation between, I think it says between the
Court
court
and
and GPD? Is that with the court and GPD? But would that also include DOE?
DOE.
That's a mistake.
It's a mistake. It should be court and DOE.
Yeah, so,
Our apologies, Chief.
you know, so telling we can have JP Torres, you know, as a site, emergency site, you know.
I think the GPD provision in there, I don't think it's a mistake, actually. I think the GPD provision in there is in the, with respect to executing the pickup orders. I think that's what that is referring to when you say the GPD, but DOE should be included in that recommendation.
And 6.3 actually covers GPD.
Yeah.
Okay.
Doris, did you want to say anything?
Yeah.
As Mr. Anderson had pointed out, I am actually the lead for the social workers with the outreach program, and I need to stress that because there really are only 11 of us for the department. And though we're assigned to a specific school, we do provide service to the other feeder schools. We have, in most cases that we're aware of, Your Honor, provided intervention or have worked directly with the child or the family to assist in what we can. Of course, we've been ordered, or we've been told, myself included, I've been attending some court proceedings. I've seen you, I've been in your courtroom, some other social workers as well. But again, the clarification is, are we allowed to attend without the subpoena? Although I have been subpoenaed for some cases. And once that case is closed, and let's say it opens again, it's a totally different case. Are we just allowed to, step right in? We've prepared reports. We've worked in RAP groups, and we've prepared reports. And again, our hands bound to legally submit something without a subpoena. And that's, I think, where it really needs to be clarified. What are we allowed to, I don't want to say promise, or, what can we do without violating whatever is going on with our department?
And I think that's where the commission comes in. I think that's where the working groups come in and the MOAs. Because if we know that you're already working with this family, the information you have is valuable to the group in the courtroom, and it's valuable for us in determining in which direction we go. A lot of times these minors can end up sitting in the department for over 2 weeks because we're gathering information. And that means probation officers going out, trying to gather information from the family. And all of that could already be in your file. So if we develop a protocol for the sharing of information, and that's one of the things I think is the larger work of the commission, is that protocol. And you're always welcome in the courtroom. Just tap somebody and say you're there.
It goes to the system of care concept. When a kid enters into the system, this kid is before a judge now, and without all the agencies reporting to us and us not knowing, we're going to put this kid through repeated same things happening when it's already done. And this kid's already traumatized by the fact that he's before the judge and he's got probation on his hounding him or her. This whole commission is about system of care. So we're trying to ensure that we're all on one working on one boat and not many different ones, because we're going to put this kid through a lot, and at the end it sometimes harms the kid more than helps, and so we're trying to avoid any repeated evaluations or whatnot, and the assistance of even background. That's the beauty of you guys, is you have this background of this kid from the time they entered into the school system to present. It's so important, and so that's why
I can also say here at Sanctuary, Ms. Bukikosa, that if we have a child that is placed with our agency under residential services, and then there's an alternative placement to that child, this I do know that with CPS, they will call us to inform us that there's a progress hearing that will be taking place, and that any information that's important that we can share. And we will appear in court. And I think, and I agree with Carol that, and also with the judge here, that if there are agencies that are involved out there, and you have some good response or good answers, it'll be very much advisable to be a part of this child's treatment team in the court, so that the judge does not sit there and figure out what to do. So I would say get involved.
Just maybe one last footnote on the BMP issue. With the judiciary and the DOE trying to get together the documents to be able to place the SROs into the schools, I think that the SROs can be a very important part of the solution as well, in the sense that we have the 5 SROs that are placed out in the high schools. For sure, any of the students who are in high school who have BMPs, and administrators are calling to report cases with students who are in violation of their probation. Those SROs that are on the campus can be very instrumental in assisting with that. We had previous discussions about SROs being liaisons anyways with the Guam Police Department, but for sure with the judiciary they can help with that, and even for the feeder schools for that high school, any students who are on probation, where those administrators would normally call probation, they could call the SRO, and the SRO can just function as the liaison to screen and make sure again, if the child has a BMP, that again, the BMPs have been, are being followed, and if not followed, they can, again, as children, you know, as advocates of those children, have those conversations with the administrators to make sure that, again, you know, by this child has a BMP and the BMP wasn't followed, therefore no action should be taken on the student. But again, part of the training piece, but I think the SROs can be very instrumental in assisting with this issue. Yeah, as part of the training, we did talk about the need for the SROs to sort of have an idea of who some of these children are that may be potentially explosive, you know, kids with emotional disabilities, and especially those campuses that have the regional programs like Agata Johnston or Southern High School, PC Lujan. They're going to need to be familiar with those programs and students who are in those programs to just be aware.
That on.
So we all agree with the recommendation that no mandatory legislation, but there needs to be several MOAs and protocols established, and that our very diligent workhorses will try to get that for us, right? Thank you. Is everybody agree on that recommendation? Any objection? Hearing none, I'll take it as unanimous. Who wants to talk about your concerns with GPD? You're sitting next to him. Hopefully he's not carrying.
Yeah.
Go ahead.
You know, Fred's my friend, but there have been issues in the past where kids on probation who are in school or even at home and they commit an offense. Let's say a kid's in school and they're in possession of marijuana. The school rightfully calls GPD, but once GPD gets wind that the kid's on probation, it seems like everything just stops there. And our position is that, yes, it is a violation, but technically that's a new charge because they're bringing drugs onto a school campus. So if they don't show up, a lot of times we're stuck going the violation route. And so what happens to the kid is we give him a violation, he goes to the judge. Basically, and what happens is, you know, he goes before the judge and the judge may lock him up or whatever the case may be. But he's not being charged for bringing that illegal substance onto the campus. And that's a problem that we have, and we've been trying to work that with GPD. Like I said, Fred's my friend, for years. I mean, I've been at juvenile probation now going on 4 years, and it's been an issue for 4 years. Sometimes we get calls from Agata. Oh, we called GPD about this kid, he did this, and they never show up. So it's 5 o'clock, and Agata calls us up and says, hey, probation, GPD never came. So what we have to do is the only thing we can do is we generate a violation based on what they're telling us, give it to the judge, and so the judge authorizes us to go pick up the kid. But a lot of those things we feel should not happen that way. That if the law is broken and when a minor's in school, that GPD should respond to that, and then decide, you know, are they gonna take him, release him, counsel him, or something. But to leave it to, probation to just put a simple violation out, somehow for us it doesn't fit. GPD knows that if there's, because if that would have occurred anywhere else, I'm sure if the kid wasn't on probation, I don't think GPD would take that stance. I really don't. I think that they would go and do what they need to do. But once probation is brought into the picture, it stops. Oh, then you got to call his probation officer. You know, he's under the jurisdiction of the courts, or she's under the jurisdiction of the courts. And our position, again, is, you know, a law has been broken. If someone gets beat up in school, you know, it's an assault. But they say, no, it's a violation of probation. So probation take that. And sometimes, I mean, some of the beatings that kids get are severe. And all we're giving them is, you know, it's a violation, judge. you know, so our hands are tied because there is no report being generated on GPD's end. And and we've spoken to Carol about it, and she too.
Graduated from
Right.
misdemeanor theft case, they're under probation, and then they aggravated assault somebody.
And it doesn't fully address the victims, restoring the victims sometimes. So the need of a new report is necessary because we want to charge it as a new case, especially where one case is about to come to a closure. And then, you know, for us to violate, you know, we're either going to extend jurisdiction, but it still doesn't, fully, yeah, it's going to be a double jeopardy issue. That's the problem. So we try to have them now keep it open-ended. When they do file a violation, then we try to work with, to see if GPD can follow up and get a police report. Because we do need that new police report. We do need to charge it as a new crime. And both crimes will be unrelated. I mean, and totally different. One could just be, it could even be beyond control. And then it becomes a possession of marijuana or something else. And, you know, we want it to be charged out as it needs to be.
I just want to say that I agree with the JJC's thing to evaluate the SOP, but on our SOP, we do have a personal rules and regs that an officer fails to handle a citizen's complaint, that they're in violation of that particular rule within our personal rules and regulations. But yes, you know, this is definitely an issue that GPD will work to correct, so we can reduce that amount of complaints of officers not taking a report when they're sent to the school and just saying it's just a probation violation.
Chief, are your general orders still applicable?
Yes, and some of them need revision, but
Yeah.
it's still applicable.
That's
we can
basically
say.
the
Yes.
code of conduct for
Yes.
police officers, right?
That's
We can
right.
post that on our website.
Yes. Okay.
So one final thing would be that it actually it would help both sides. So on one hand, about 10 minutes ago, we're talking about how we want to be softer on kids who have emotional issues, and then we have some who could be serious. So this way could also clarify that as well. Those who are real conduct, no empathy, kind of on the track for lifetime chronic offenders. Those can be identified as well, as opposed to being minimized. Oh, well, that's just a violation. Yeah, but he cracked the guy's skull. Oh, there's a theft and there's a violation. You know, that type of thing. So that can also be discerned if you do it right, if it's
I
done
think
right.
it goes hand in hand with the above.
Yeah.
I mean, you know.
Those who need help and
the
those
kid
who are
who's in an IP, who
chronic.
has a BMP, these are the protocols to follow versus on that.
So is everybody in agreement with the recommendation that we work something out? The two friends over there will write something? So your other friend on the other side, you can talk about the next one now.
Yeah, in talking to my friend on the right side, she's relayed to me that it's a domino effect thing. It's basically what happens is that we have hearings, petitions come in, and so we know that there's hearings on certain cases for certain kids on that day. He'll come to us and he'll call us and say, probation, what happened? You know, you weren't in my courtroom. So then I go to my friend here on my right and I say, you know, we didn't receive the documents. And then her response to me is, well, GPD just filed it or is filing late. That way, in that case, we can't get everything together and give it to you to get to where you need to be. So I really like my AG on the right and I like my GPD on the left. But basically, yeah, I don't know, because I don't know how GPD works on that end of generating reports and what time they have to turn it in, and if it has to be turned in by a certain time to get to the AG so the AG can actually charge it out, give them enough time to charge it out, and then inform the court that there's going to be a hearing. So I don't know how to.
I'll defer to
the judge.
On that timing problem.
Oh, he knows that.
I think those of us who are involved in that front end of the juvenile justice system, we've talked about this at length. And one of the things that I was hoping to recommend once the full commission is established is that when officers are assigned to the juvenile investigation section, they really should be assigned for a term, and a term of anywhere from 3 to 4 years with transition planning, because this is such a specialized area of law and a specialized area of skill sets. And it's unfair to the officers that are simply taken from the field in other law enforcement functions and said, here, now you're juvenile investigation. Now you have the whole system of child welfare and juvenile justice screaming at the front end of the line that you're holding up the line and you're not following the protocols, which I hope is what the website on the commission is going to take care of as well in many ways. That's all.
I just wanted to point out, as he mentioned, we do file late. We receive reports pretty late, too. And with my division, we try to keep us at full prosecution, and when I say full, 100%. A report comes in, they're charged. Either if it warrants charging, they're charged. If it warrants, decline, it's decline. But what I'm getting at is action is taken the minute a report lands in my division's hands. Because, we believe in our concept is a juvenile needs to be brought before the system as soon as possible. In all aspects, that when a crime is committed by a juvenile offender, they need to be before the system quickly so we can service them. That's the only way they're going to learn. And so what happens is we, with the transition, that's what I just spoke to Chief prior to this, that I was going to be meeting with him to talk to him about some of the issues. And one of it happens to be receiving the reports really untimely. We get the reports after 11. We have to be in court by 2. So imagine my attorneys are working through lunch to charge out this case so that we can be heard before the judge at 2. Otherwise, we would be releasing these offenders into the community. And we don't want to do that if it compromises the safety or without knowing the risk that it's going to cause. So my attorneys know that, and they stay and work until these things are done. And judge will tell you, and he just said it, sometimes they don't get the filed stuff until like 1:30, close to 2 o'clock. And we get chewed out, but it's okay, because we're going to take it on our end that this is when we got the report. We did it as quickly as we could in the most timely fashion that we could do it upon receiving it. And I work with probation. If they have prior offenses and I can have a pick-up order on a lockup on a violation of just a general, they violated Guam law, then I can work with them on that if the report comes in too late, because the judge is waiting for us all the time. And so I was going to talk to Chief about that, and I think it's just a problem of getting it into the LERM system, and sometimes it comes incomplete as well. Like we have patrols report, we don't have GIS's report, or we have GIS's but we don't have the rest of the patrol. So how it gets into the system and when it gets to us is most of the time we never gotten a report before 10 o'clock. So.
But part of the problem is not just the ones that you have that are in custody, that you need to get 10 or 11. The other part is, at least when I was there for the 10 years, was when you go to a kid and say, 11 months ago you committed this, they're like,
I don't remember, but I probably did.
Yeah, and it just, it doesn't, they don't understand why you're punishing them or why they're there before you. So there really has to be a more timely, when I looked at this, that was the one that I was most concerned about, was the timely one. And when you were talking, I was hoping maybe that the young men that stole my car and torched it, that they went juvenile, and that's why I don't know about it. But,
Yes, things, like I said, I asked Chief to speak with him earlier, before this meeting, and those are issues that will be brought up. The issue you just brought up is one of the issues as well. We see that we see it in some of our reports. And our main concern is, the statute of limitations sometimes runs on these crimes. And so by the time we get the report, although it came to us, the statute ran already, so it's a decline. And we don't want to see those numbers. We want this is our time to rehabilitate our youth before they enter into the adult world. And we miss these little cases that mean very little to a lot of people or are just so petty. Well, those are the petty ones that we should catch to help and fix so they understand it's a crime, because we don't want them graduating to his world where, they can jump from theft to murder, and we don't want that. And that's what we see. We see an escalation in a crime. What started very small, it jumped up to a second-degree felony. What started as a petty misdemeanor is now we're now seeing them in the system with felonies that were skyrocketed high. And so we get the report at the same time. We're like, wow, they committed this a while back, you know. But now it's coming in together in one report, and we have to sort both out. And so it's some things that I want to sit down and talk with him. I've spoken to my boss over here about it, so.
Well, I'm glad
we
the
wanna
discussion
resolve
has started, and
Mhm,
so
yes.
that means that everybody's in agreement with the recommendation that discussions have to be
Yes.
entered into between the two of you and to address the concerns of the court. Is everybody in agreement with that one?
Yes.
Thank you. Oh, client services, foster care.
Oh, you're done.
Do you want to?
Vice Speaker, there's no one here from Client Services today, so this might, okay.
Basically, for most of for the foster care, I was waiting for the probation officer to say he likes his judge too, but I was listening carefully for that. Most of the kids who come into the court come in under a PINS petition, and that's how they get into foster care. I think that all of the child serving agencies have been strained to the point where we can't keep up with all of the timeline demands of a PINS petition. And that's the concern is from client services is how do we get these children transferred into foster care and resolve the PINS petition quickly, because sometimes they're still living at cottage home or in relative placements, which in counseling becomes difficult. But again, it's not a matter of change the law. It's a matter of we all as agencies need to sit down and work on it. So does anyone have any questions on that section? Lydia?
As a matter of understanding this, is client services saying that they're not able to provide the good comprehensive treatment unless they're back into their home with families? Is that, because unless they're in their home, it deters or delays the reunification? Is that?
That it's difficult to address
understanding?
counseling with persons who are still in limbo as to their status. Because really, what are you counseling to in terms of progression? I think that's what they're saying in that section.
Well, yeah, I can see, that makes sense, unless, of course, I think part of the problem is, in the proceedings, is, if there are ongoing criminal proceedings, I think we talked about this in the past, the parents usually cannot admit to anything at that point, and so there's variations with the process of family court versus criminal court. That's one thing. Another thing is if we don't engage in a service plan agreement with the families, usually services are held back as well. So that's a second thing. Another thing is, depending on the judges, some judges want to move forward with the permanency, whatever that may be, and some don't. Some just continue, regardless of the recommendation we have, regardless of the timeline spelled out in the act. The cases are still held back, because the judges are still, I guess, giving the parents the opportunity to do what they need to do. And there's these extensions that continue, and they're on and on, going on. But I can see where, if they're wanting to address the whole comprehensive reunification, that would be a problem versus the individualized needs at the time of that child. So it really depends on what the treatment plan and perspective is at the time. So if maybe Virginia wants to clarify further. But we usually deal, if the kids are in counseling at that time, it's to work with the trauma and the separation and the victimization at that point. And reunification will usually be recommended when we know that the opportunity is there for that to occur.
Yeah, I think it has to do with the timeframe, insofar as moving in along in the Pins case into permanency, because a lot of times we have these kids just hanging onto foster. And so I think right now we're drafting the Child Protective Act, and we're going to be, there are current timeframes on it, but some of the time, it's pretty much very general timeframes. So what we're trying to do is develop a more specific timeframe to follow.
I think my question that I have here for, in terms of foster care, because this is something that we have actually, seen happen at Sanctuary, and it's not on anybody's fault. But, our program is a 30-day program, and whenever we get referrals coming in and we find it deemed appropriate from CPS, in many cases, the kids are there more than 30 days. And that has been a growing issue with us, although we are very, we're able to work with CPS. And I think the question that I have here is, I haven't heard really kind of like a set time as to when do CPS draw the conclusion in terms of, not looking into reunification or, reconciliation. And that is where we tend to sit back and wait. And I know that, with CPS, you have done a great job in trying to find alternative placements, but yet we still need to be very mindful that, we do have a time frame. And Lydia, I know that our director have spoken a lot with you, and we always tend to come to an agreeable solution here. But I think that is a question that I have. When do we draw the line?
Well, currently the law is 18 months from the time that the minor enters into the foster care system. So that's the current law. That's an outdated law. In the states, it's as short as 6 months. In some jurisdictions, depending on circumstances, and there's actually it's a federal mandate that certain situations would even permit the government to move in on termination right away. And when it's like death of a child, where a parent kills it, there are certain situations where the federal mandates provide that CPS can, rather than engage in services, just move in for automatic termination. So all those areas we're trying to incorporate into our law now, because we want to meet this 2001 federal mandate. And our laws have been since the 90s. It hasn't been touched, correct? And there were 2 changes into the CAPTA, which is the Child Abuse Prevention Treatment Act, as well as the AFSA, which is the Adoptions Family Safe Act. And so we're using both of those federal mandates, and we're reviewing Ninth Circuit jurisdictions because we fall under Ninth Circuit. So we're looking at California's law, Oregon's, and Washington's, and we're looking. They're pretty much consistent with it. But what I'm trying to get at is there's tighter time frames that we're trying to modify our statutes to reflect. So it would be laid out.
I'm sorry. I was just going to say, and then in previous discussion also, in terms of what CPS was asking for, is that when we bring cases before the court, we'd like for the parents to admit to either the abuse or neglect, and just not admit that these children are a person in need of services at the forefront. And that's what we're asking for, so that it could help to expedite the proceedings. Because the usual is that they're there, they don't admit to the abuse or neglect, but they will admit that the child is a person in need of services. And so that kind of also delays reunification and moving towards permanency. So, earlier discussion also dealt with that kind of issue.
First of all, I agree with George, and he said they do a great job. I think it's an amazing job. When I read the petitions, the fact that CPS can even find families for many of these kids and appropriate shelter for them, so that we can let the court process take its course. Chief, I just wanted to go down and say most of the stuff left on these are client services, and they all reflect the same thing, that we should meet in group discussions and develop protocols. I don't want to hold up the rest of the working group because it seems that all of these recommendations are to go back to the commission. And I would ask that we consider all of them at one time, unless anybody has any objections. That way we can close this section.
That's fine. But I really do think that at some point, we're going to have to address that. And you're going to need to talk to your client services. Their recommendation is really saying that, and I know I was guilty of it when I was there, was that we just kept dragging it and dragging it and dragging it. And it really is a disservice to the child and to the system that we don't have a permanency plan and agree that after 6 months, at most 18 or 12, that it's finished. And the child knows where they're going to be and how they're going to, and they can start moving forward and healing, as opposed to, well, we have another hearing in 3 months, and I don't know where I'm going to be. And so I think it's, where the thing that says no change in the law, I think maybe we should take that part out. And
Yeah.
there are proposals that need to be made and some fairly major pieces of legislation addressing this, because this, for me at least, having been there at one time, these are going to be really, really difficult to address. And trying to get the 7 judges to agree that it's 6 months or it's 12 months, you guys are going to need to send somebody over to testify that you agree to one of those timelines, because I know when I was over there, none of us could agree as to what was the appropriate length of time that you keep the child in the system as you keep hoping and praying for some kind of solution.
Actually, I mean, I have a lot of ideas on how to do that, Chief, but it's not that I wanted to minimize the effects of these recommendations. It's just that I recognize, like you do, that this is going to be a much larger, more in-depth and more comprehensive discussion, which can appropriately take place at the commission level in more staff work, because this really is a very big piece.
I just wanted to chime in with the vice speaker's voice, and the time frame is really important because Lyd can support me on this. We've lost a lot of actual placements of families, military families that were willing to adopt or take, a permanent placement of these kids, and it's been lost because of lack of an appropriate following of the time frames. And so, it's just really hard. We don't have many foster parents. We don't have many therapeutic foster parents, and it takes a good family to step up to the plate and want these kids that are in distress. And then when we lose them, it's hard because we have to we're right back at square one searching. And so it's happened in the system, and that's why timeframes are really important.
Okay. So on the judge's recommendation that we take all 4 and refer it to the commission that we're hoping to create in 8. Oh, 6 of them. Is everybody in agreement with that? Because these are, surprisingly, actually, where the most pieces of legislation's coming out of. We managed to get through 6 sections and not have very many pieces of legislation, but this one's going to come up with the most major pieces.
Mr. Vice Speaker, I do think that 7.3 does need a separate, if short, discussion, only because it recommends creating a new misdemeanor. And if that's something that the commission agrees on, then it should be referred. If it's not something the commission agrees on, then
7 point what?
7.3. I mean, that's
Oh,
the only one that's different.
I think that's the change of, part of it is changing the language of, what is it? Jurisdiction over a minor, and many of, even, yeah, I think, so. Okay. And I think we agreed that we would change that? Yes, okay. So then we've taken care of all of 7. Is that everybody? 8. Correct, that we need more time on that one, and then the permanent commission should do that. Okay. 8.1 on school resource officer, we'll let the board meet day after tomorrow, and the legislature meets next week, and we'll see which one says what.
Bill?
For the record, I had Pat call up legal counsel for DOE requesting for the MOU, and we're still waiting.
To request the MOA with judiciary?
Judiciary.
Regarding the
and DOE.
SROs? Regarding the SROs?
Yes,
It's still in development.
Yeah.
yeah, okay.
Yeah.
It went over today for their legal counsel to review.
Okay.
Yeah, I just want to reflect on the recommendation from the working group, because I don't know, I may have been sleeping at the time. However, I don't recall the recommendation to institutionalize the SROs under DOE.
It was
that-
brought up at one of the meetings that your truancy officers, eventually you were planning to either
Converge.
merge them or convert
Yeah.
them into SROs, so that it becomes a permanent position with the Department of Education.
So once that happens, then we lose the federal funding because then it becomes a local.
Yeah.
I don't think it's gonna happen anytime soon. I think it's along the road, that was your plan, so eventually it's something,
Yeah, well,
they were
No,
trying
I
to
mean,
make truancy
the-
officers SROs.
well, I guess what I was trying to, what I was trying to articulate, and I probably didn't do a good job of it, but nonetheless. When we were going back to that whole discussion about the attendance officers and the fact that they were excluded specifically for the 10%, they were considered law enforcement, but for the purposes of compensation, they were completely excluded. Well, my strategy was to try and shape it from the perspective that, the attendance officers, being law enforcement or peace officers, at some point, we can expand their responsibilities, not to move away from their primary responsibilities as attendance officers and handling that particular clientele, but to just increase the level of responsibilities to take on some more of the SRO responsibilities so that they could augment that. So it's not really to absorb SROs into DOE staffing, because I think that's been our problem. We're not able to attract and get people to want to work under the Department of Education in a retired police officer capacity to want to come and do this. Plus, what our superintendent just mentioned about there's issues with grant funding if you do that too. So that if they're, on our local staffing pattern, we wouldn't be able to federally to be able to pay for that federally. So I just want to clarify, I guess, in the recommendations that.
Yeah, I think if we'll just wait and see what the board or the legislature does on that one, and that at some point, the federal grant isn't going to go forever. You're not going to be
Right.
able to have them on for
Right.
30 years. So if it is at some point going to be done, whether or not it's appropriate to be crossing branches, and whether or not they are more appropriately executive employees as opposed to judicial employees on loan. So everybody agrees then that we'll await one of the two policy boards doing something. On 8.2, on permanizing this commission, again, the draft legislation is just that, draft. But I think all I'd like to do is get this group's concurrence that some kind of legislation permanizing and you doing the things that Judge Barcinas is talking about, of having a website that everybody, not from probation officers and school resource officers to judges, understand how we all hope, or at least the commission hopes, that we all treat these young people, regardless of whether or not we've been rotated up or out or whatever, that once the police officer's 3 years are up and he gets promoted to be lieutenant, that we don't have people that are not familiar with the area, or at least that if they aren't familiar, that there's some place that they can go readily to get that information. So can I get a vote on 8.2 in agreement that this is how we go? Everybody's agreeing? The last one that's going to be hard is 8.3, and I'll let, who
law regarding valid court orders. I know this came from Dr. Rapadas also. This basically would say status offenders would never go to ICF.
Only because it has that, it's part of the OJJDP DSO thing, so it's not like it's, and plus there is a law that already exists. Yeah, the deinstitution of status offenders. I'm not sure why we're trying to reinforce it, or it's part of the law, isn't it?
This is the way the law is right now. So
Yeah,
we need to
that's-
take it out. What I'm suggesting is, if that's the goal of the commission, to remove that part of existing law. This is still there.
Point of clarification, when we took a look at this, we saw that it was not aligned with, there was some inconsistencies. So that's why the recommendations are being made, so that it can be consistent with other parts of the law. Like you mentioned, the DSO law is part of the DYA Act, but yet there are parts of that act that are not in compliance with the DSO. So there, in fact, we even found another error in terms of when they were, the citation, which one was it, Jerry? There was a citation that doesn't even exist, that was in the law. So there's some technical things within the Youth Affairs Act that needs to be updated.
Not necessarily vote on this one.
We're voting on?
Yeah, well, yeah, without researching and looking at what the inconsistencies are.
Yeah.
I say
Can I make the amendment that the recommendation be to send it again to the commission, which is the larger work group? And because these things have to be very carefully, yeah. That would be my recommendation, to send it to the work group.
On the
The commission.
recommendation of Judge Barcinas for 8-3. Is everybody in agreement?
Yeah.
Okay. Then, as a final, to comply with everything, I need a ratification on what we did 1 through 6. No. Was it? No, 1 through 6.
Okay, I moved around.
From the previous,
Oh, that's 1 to 5.
1 to 5. On the previous days that we met, we took some action. Is there, I'll accept a motion to ratify all the actions.
Our actions for the first 6 items.
So everybody agrees that the actions taken the first 2 meetings with regards to 1 through 5 or 6 are 5 are all adopted by us 9-0, correct?
Yes.
Thank you. And as Sarah was saying, this is the first time that we've been able to gather together people of this caliber for 4 meetings in a row. And I really, really want to thank everybody. And I'm hoping that the listening audience will appreciate the fact that people of your stature were willing to sit down and go through these things. The importance that we all place in our children, and that we're trying very hard to address some of these issues, and they're very, very sticky, and that's why we're recommending that some permanent group continue to look at this, because we can't let another 30 years lapse from 83 to 2013 before somebody sits down and looks at this again. It's got to be something that is looked at because times change and people change, and we've got to figure out whether or not we're on top of it. And on behalf of all of us that were named to the commission, I want to really thank all of you, the staff, the working group that devoted literally hundreds of hours, because I know Judge Barcinas hosted a couple of meetings at his office. There were many at mine, and you hosted one at GDOE, and you guys hosted one up at Public Health across the street, and several meetings. And I know that you guys spent lots of hours. All of the concerns that you sent in and all the previous PowerPoints were really appreciated, and it helped all of us try to focus. I mean, when we first met, it just seemed like an impossible task to try to address this elephant. And we've taken it one bite at a time, and recognizing that though we've got 2 of the legs done, we've got the major carcass left ahead of us. And that we're having this new commission that we want to permanentize address that bigger part. And so I want to thank everybody for your diligence, your cooperation, and your attendance. And if anybody else wishes to make a closing comment, I would appreciate it. Accept. Your Honor?
Oh, no, I really appreciate it. I am excited to get started on the work at the commission level, because this is just laying the groundwork for that forum in which we want to do it. Thank you, Chief, for accommodating us and hosting us. We know your schedule is as busy as everyone else's, and I think when we talk to you and we see your historical perspective from the bench and what you want to see going forward, hopefully we'll be successful in getting that done. Thank you.
Mr. Chair, I just want to thank you too, that as the only NGO here from the nonprofit sector, I really thank you for allowing us to be a part of this team and a part of this discussion. And I know that our director is very honored that we are involved in some of the discussions and decisions.
The proposed law will include NGOs, and you're not getting away that easy. So don't be saying goodbye now. Anybody else? All right, thank you, and we stand adjourned.